Thanks for choosing us. We are your home of independent, fearless, and credible journalism. Well, this afternoon, expectations among Ghanaians are soaring, and anticipation within the legal community has reached a crescendo as the suspended Chief Justice Gertrude Torkornoo prepares to break her silence and address the nation in the next few minutes over her recent suspension. Well, we know that President John Dramani Mahama suspended Justice Gertrude Torkornoo on the 22nd of April 2025 following the receipt of 3 petitions alleging misconduct against her. The President, in consultation with the Council of State, found a prima facie case against her. As part of the process, a 5-member inquiry committee was set up to examine the petition and determine further action. This marks the first time a Ghanaian Chief Justice has been suspended under the 1992 Constitution. After 2 months of silence, the suspended Chief Justice Gertrude Torkornoo is finally set to speak, and the nation is watching closely. What is she about to reveal? Will she choose to resign, or will she fight to clear her name? If she steps down, what would be the implications for her career, her retirement benefits especially, and her legacy? How would her resignation affect the ongoing inquiry? Will it pause, will it alter, or end the committee's work altogether? And if she exits, does that automatically alleviate the acting Chief Justice to top post? Or will there be another Chief Justice? Well, beyond the legal consequences, what message will all this send about Ghana's justice system, its institution, and the country's global image? We'll get all the answers and expert analysis here on The Pulse. But for now, let me cross over to my colleague, Michael Ashale. He's on the grounds right now, and we're touching base with him just to get a sense of the euphoria on the ground, because the Chief Justice is about to speak. Michael, what can you report?
We are coming to you live from the Palms, formerly known as the Holiday Inn, where we are expecting the 4th gentleman stroke lady of Ghana expected to address the nation on some issues that are currently ongoing. What exactly we don't know is what direction this conversation may take, but one thing we are certain about is that this conversation definitely will be a groundbreaking one, possibly define our legal landscape for years to come. Rightly, as you have mentioned, that Justice Gertrude Torkornoo has been involved in some number of legal battles since February, when some of the first petitions in this year were filed against her, essentially calling for her removal. In a bit, we'll go through what exactly some of these petitions have been saying and what exactly allegations they've been raising against her as well. But what we know for a fact right now is that Chief Justice Gertrude Torkornoo, who is now suspended and embattled, will possibly walk in a few moments from now and address the nation. A few weeks ago, although, we know that Chief Justice Gertrude Torkornoo herself wrote to the Supreme Court asking for a number of reliefs, and one of them was to also complain about the sort of treatment at the committee that is supposed to be investigating these petitions and the allegations they have raised against her, and also advise John Dramani Mahama, who is also the gentleman at the center of this, or what to do with these allegations and whether to sack her or to keep her on the job. So whatever she has to say today definitely will be groundbreaking. Firstly, at this point in time, maybe we want to, whilst we are waiting for Chief Justice Gertrude Torkornoo to walk in a few moments, we've seen a lot of Land Cruisers, some of them with police escort. We are expecting that possibly one of them will have her in it. We've also seen some MPP lawyers who have also driven around here just moments ago. But as of February 14th, 2025, we know that the first set of 3 petitions was filed to John Dramani Mahama. Now, this one came from a group known as the Shining Stars of Ghana, led by Kingsley AJ, and it tells us that they may raise some number of issues, but mainly in 2 categories. The first one was that misbehavior and incompetence, and they think that for these reasons, Chief Justice Gertrude Torkornoo should not keep her job and should be asked to go home. But I'll walk you through some of them. Misbehavior, though, that group, Shining Stars of Ghana, said that they accused the CJ of breaching Article 144 of the Constitution by writing to former President Nana Addo Dankwa Akufo-Addo on May 30th, 2024, recommending 5 appointments to the Supreme Court, a role they claimed exceeded her constitutional mandate. Again, one key issue the group raised was that she was incompetent, and to buttress their point, they alleged that the CJ were presiding over a case brought by the then majority leader, Alexander Fenyo-Markin, following that decision, controversial decision from Speaker Bansumani Bagbin, to sort of bar some MPs, many of whom were majority MPs at the time, from carrying themselves out as members of parliament. The group alleges that by virtue of the Supreme Court sitting on that case, barring some other restrictions, she made some key errors and shouldn't have done that, and they thought that that constitutes incompetence on her part as the Chief Justice and should be sacked from her job. One of the major reliefs for this group is that her removal based on a demonstration of incompetence and breach of constitutional process. Also, not long after that, there was a second petition that was received from ACP Ayamga Yakubu Akogo. We know that that person is a senior police officer. Now, they raised a number of issues, and again, the final thing was that she essentially thought that, or this petitioner also thought that Chief Justice Gertrude ought to lose her job. And then there was a final one that also came sometime in March, filed by Daniel Ofori. And then, so all these three, we understand John Mahama eventually, after some battle between himself and Justice Gertrude Torkornoo, sent that to the Council of State. So just in your shot, you are seeing the lady of the moment, the woman we are all waiting for, who we understand has been having her own issues for some months now, but Chief Justice Gertrude Torkornoo just walking in there in the company of security, also hoping that hopefully they currently help us understand what exactly is happening here. So you are just seeing in your shots there Chief Justice Gertrude Torkornoo, who in a few moments from now will be addressing the media. Tell us exactly what she's been keeping on her heart. We know that the conversations at the committee level have been in camera, not so much out there. Possibly today we may get in the first hand into what exactly is happening at this moment in time. So Chief Justice Gertrude Torkornoo walking majestically, taking her step, taking all her time in the world to walk into the auditorium where we're expecting her to address the media a few moments from now. But again, we know that three petitions currently are before a committee that are supposed to investigate the allegations and also recommend to President John Dramani Mahama what exactly to do to sack the Chief Justice and appoint a new one, or to keep her on the job at the moment. What currently possibly the fear is that, or the concerns, or what we are expecting possibly from today's press conference is that she will possibly be either making more complaints about the in-camera hearings, or possibly give us a groundbreaking story about whether she's going to keep her job. But that is a question she alone can answer at this moment in time. So she's just taking her seat and possibly set up for senior staff. But Chief Justice Gertrude Torkornoo at the moment is in the embattled fourth lady of the land currently is here to do what has never been done, to hear from the Chief Justice of the land. Never happened before. In fact, we've never heard from a Chief Justice who have been suspended from her job. And whatever will happen here will reverberate or have repercussions on the legal landscape for years to come, and not just in the year 2025. So in a few moments, we'll hear from Chief Justice Gertrude Torkornoo and find out from exactly what will happen here. Earlier I was mentioning there were three petitions that have been filed, many of them making some allegations of her incompetence, making some decisions they felt that was not her legal area of expertise or she needed to speak on. And then also those conversations about some misappropriation of monies given to her for some travel that she also did. In a few minutes, we'll hear from her.
Well, interesting. My colleague Michael Ashale live on the grounds there. You saw in your shorts the suspended Chief Justice Gertrude Torkornoo taking her seat. She's about to address the nation. This is history in the making. This is the first time a suspended Chief Justice would be speaking to the nation. Well, we know that the former Attorney General, Alfred Chiayuba, will be joining us on this conversation via Zoom, just to get his thoughts on this. But with me in the studio, I have a leading member of our research desk, just to give us a breakdown of some of the key things that she's going against, the three petitions, and then why exactly this is happening to her at this point. But let me bring in Alfred Chiayuba just to get his brief thoughts. This is the first time we're hearing from a suspended Chief Justice address the nation even before we're having official response or even an official detailed breakdown of probably findings from her investigations. Will she resign? Is that a thought on your mind this afternoon?
Good afternoon, my sister.
Good afternoon.
Yeah, you are right. That is the first time that you have a sitting Chief Justice who has been suspended, meeting the media to address the media on some pertinent issues on her mind. As to the issue that she's going to address, I think we do not know, but definitely it is my expectation that she will touch on the removal proceedings pending against her. As to whether she'll resign, I think I know the CJ, the suspended CJ, she's a consummate jurist and she understands due process. And I do not think, I may be wrong, that she may want to tread along that line. But who knows? Let's wait and see.
Let's wait and see. And that's what we're waiting to find out what exactly she would say. But that supplementary affidavit that she put out that have since been made public gave us a sense of what is going through in her mind. And I'll just read portions of that affidavit. I have it with me here. Point 12 of that affidavit, she goes on to state that other developments like denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephones and laptops for myself and my lawyers, even though counsel for petitioners have access to their phones and laptops, and the conduct of the hearing itself in a high security zone at the premises of the Castle Osu show a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental rights. That's the first time we heard from her talking about her thoughts of how she felt she had been treated. But that affidavit, we since know the Supreme Court has struck out. Your thoughts on this, though?
Yes, those issues contained in the supplementary affidavit are very serious issues, and they are issues bordering on human rights. And I've not cited any provision anywhere which indicates that if you are facing impeachment or removal proceedings in camera, your rights could be abused anyhow. And so I was surprised when the Supreme Court in this ruling started to strike out that supplementary affidavit. Because as a student, as a lawyer, I know as a fact that fundamental human rights are so basic. It matters not where the proceedings are being held. Those who are holding the said proceedings must uphold the highest standard when it comes to the protection of fundamental human rights. And so I was just actually surprised that that supplementary affidavit was disallowed by the Supreme Court.
And in your shots, you can see now the Chief Justice seated, ready to address the media, and we're taking their live once it starts. But I'm still picking your thoughts on some of the key concerns you raised in this affidavit. Now, she also raised concerns about the individuals on the committee, and she feels that it is actually wrong. For some of them, she alleges they have personal interest in this. At this point, from where you sit, what would be the prudent step the Chief Justice should take? To walk away or hold on and keep fighting?
The Chief Justice, Mrs. Torkornoo, from what we've read from her response to the petition, is of the candid view that she's not guilty of any allegations being leveled against her. And for that matter, I expect her to stand and fight this petition before the committee. But what I do not want to see is a situation whereby when she decides to fight this petition before the committee, her rights are abused. And because in that particular proceedings is being held in camera, and because the Supreme Court has also struck down that application because from their point of view, it breached Section 146(8) of the Constitution, the CJ may not have any option than maybe go out and state her predicament if her rights are being abused. Because from what the Supreme Court said, it appears that if the CJ cannot go to Human Rights Court to ventilate her concerns if her rights are being abused. But let's see what she has to say today.
Let's see what she has to say today, indeed. We're looking forward to that. And on your screens is that live visuals we're bringing you from Accra, where she's about to address the media. We're looking forward to some of the key things she would be raising. But then we know that the supplementary affidavits give us a sense of some of the key concerns she has raised. And then let me just go back to the same affidavits and quote other portions of it. She says in point 11 that this is completely offensive to known rules of procedure regulating the work of committees, commissions of inquiry as so-called petitioners or complainers when they formally appear before the committee or commission of inquiry are mere witnesses whose evidence will have to be taken and cross-examined on oath by the person affected by the proceedings. Now, let me read the 10th point, which gives a bit of context to this next paragraph. It says that that is point 9, really, that on the previous adjournment date of the committee sitting on the 15th of May 2025, at which I was represented by counsel, the committee refused to recognize my counsel simply because I was not personally present and proceeded to fix subsequent hearing dates and make arrangements for the hearing without involving my counsel. Is that the right procedure?
I disagree with that procedure if indeed it did happen.
Okay.
Now, lawyers are engaged by their clients to represent them at various fora. It could be courts, commission of inquiry, etc., etc. So far as a lawyer has appeared before a committee or a court to indicate that he's representing a client, he must be heard. And the hearing may be that, counsel, you are representing Mr. A. For today, we'll put you on record. But on the next agenda date, your client will have to be present before us. I mean, that would be a fair request. But if the committee, as we've been told, decide not to grant audience to counsel for the CJ, it is an aberration. It's something that any judicial process should not countenance. If a lawyer appears and the committee's opinion that that lawyer is not even a lawyer, in quote, they'll have a way of checking such a lawyer. But I do not think if such a thing happened, it should countenance.
Okay, let me cut you at this point because she has started and it's the first time the Chief Justice is addressing the nation. Let's listen in.
Involved in as Chief Justice is historic. In all of Ghana's 68-year history as an independent republic, there has never been a hearing for the removal of the Chief Justice. One would therefore have hoped that if such a process becomes necessary, it would provide good guidance and precedent for nation building. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The second reason for making this statement is though I'm in the process alone, its effects ripple far beyond me as a person. This process will affect how all Superior Court justices and future Chief Justices may be removed from office. It also affects commissioners and heads of independent constitutional bodies set up to protect the freedom and justice of Ghanaian citizens as guaranteed under the 1992 Constitution. In building Ghana's democracy in the Fourth Republic, the framers of the Constitution identified public officials who must directly serve the citizens of Ghana without being afraid of unjustified punishment or reprisals from influential people or members of the executive or legislature. The framers of the Constitution identified that it is only when these public officials we can work without fear, control, or at the pleasure of influential people that freedom and justice will reign in Ghana. The law did not provide for the termination of their appointments by any authority. The Constitution set up grounds and processes for removing them from office under Article 146. And these grounds must reach the standard of, quote, inability to perform the functions of their office. The officials include, apart from Superior Court justices, commissioners of Traj, commissioners of NCCE, commissioners of the Auditor General, and the chairman and the vice chairman and members of the Public Service Commission. The third reason for this statement is that in order to address the troubling violations of the Constitution and illegality of the proceedings that have become obvious to me, that became obvious to me from the beginning of the process. I started an action in the Supreme Court. I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order or safety. I realize that in my case, should the public be made aware of the allegations in the petition, they would realize that none of the allegations made border even remotely on matters of national interest or matters of public order or safety, or anything that indicates that I'm unable to perform the functions of my office. An example is an allegation that I failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana, from my journey. And so I knew that it was necessary that the issues being thrown around as petitions against me needed to get into the public space. I swore to a supplementary affidavit alerting the Supreme Court also of human rights violations that I had started encountering when I went to the Article 146 hearings. However, the members of the Supreme Court that had the application for the hearing in open, and they also struck out the supplementary affidavit at the request of the Attorney General. I have decided to make this statement today because the violations have not stopped. Indeed, they have escalated beyond anything I could have imagined as possible in justice delivery. These violations include the committee's refusal in breach of the rules of natural justice, to recognize my lawyer on the first day of proceedings, simply because I was not personally present with him. And they went ahead to make arrangements for the hearing without involving my lawyer while he was sitting in front of them. The committee has also failed to indicate the specific charges that I'm supposed to be defending myself against in order to allow me to adequately prepare a defense to the charges. The committee has gone on to permit two of the petitioners, Mr. Daniel Ofori and Shining Stars, not to testify at all or present what case they brought to them at the hearing. The committee has refused to allow me to go into the hearing with any family member. Before you enter, there's a thorough search of my body and my handbag in violation of protocols and courtesies extended to any Chief Justice, which protocols and courtesies are honored in the name of the nation, both in Ghana and outside of Ghana. And then the work of the committee is being conducted in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 have been held in facilities of the Judicial Service. It is hard not to reach the conclusion that the choice of venue against the backdrop of secrecy of proceedings is intended to intimidate me and to prevent any citizen of Ghana from knowing how the proceedings are being conducted. The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samakwa, a military officer who was killed with the 3 High Court justices, who was a director of human resource of GIHOC. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. At this Article 146 hearing, no rules provided by law to regulate the fairness of hearings and trials in this country are being followed. As we all know, when a citizen is summoned before a court or any administrative or disciplinary committee, it is the duty of the committee or court to give the citizen a copy of the complaint that they are presiding over. You cannot be summoned without a writ, a petition, or a complaint. It is also the duty of that committee or court or tribunal to give copies of all documents that have been filed with them before the hearing is started. How does anyone defend themselves without a copy of the complaint that they have been summoned to come and answer to? This Article 146 committee has refused to give me copies of the petitions that His Excellency the President gave to them. They refused to give me copies, a copy of the prima facie determination that His Excellency the President is supposed to have given to them. They claim that they know that the President sent me copies on 27th March of the petition on 27th March 2025. And so they do not need to show me what the president gave to them. They also claim to have copies of the responses that I gave to the president, but they will not provide the petitioners with copies of my responses. The difficulty with this is, because they are the independent body charged with the duty to conduct the hearing, what I have in my hand from the president could be different from what they have. And I cannot assume that the two copies are the same. Indeed, no tribunal does that. No tribunal will tell you that before you came here, we know that your landlord wrote to you, so we are looking into what your landlord wrote to you about, and so that is what we will be inquiring into. They will give you what the charges are that they are supposed to be inquiring into. Second, the petition itself has not been admitted into evidence and subjected to cross-examination by me or my lawyers. In this case, because they have permitted the petitioner who has so far given evidence of whose petition we are supposed to be dealing with, Mr. Daniel Ofori, they have permitted him not to testify and confirm on oath what his petition is. There is no petition on the table. There is no evidence given by him on oath. He has not authorized anyone to testify on his behalf. So what are we inquiring into? Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote-unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that it will conduct the hearing not as an inquiry, but as litigation. So they rejected the use of CI 65, which was created for the regulation of inquiries, and said they will use the High Court Civil Procedure Rules, CI 47. Then they decided that each petitioner can conduct his case as he sees fit. So they don't need to present the petition to them. Then they decided that the petitioners can call public officials to confirm what they themselves have not testified to. So, ladies and gentlemen, because the proceedings are being conducted as if it is a normal litigation between the petitioners and myself, their lawyers now choose and pick which parts of the evidence that public officials present to put on the table. This is also in violation of known rules regarding proceedings of a committee of inquiry, because a committee of inquiry must have its own lawyer, and when it starts the proceedings, the petitioner becomes no more than a witness for the committee to prove the allegations that led to the setting up of the committee of inquiry. So the public officials who have been summoned supposedly on subpoenas without the issue of subpoenas just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition, and so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed up, and witness after witness has been called, like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it. My lawyers are left to guess which allegations in the petitions that I received on 27th March are supposed to be the subject matter of the testimonies that the witnesses have referred to. Anyone who has been to the Circuit Court or the High Court and made subject to the rules CI 47 will know that those rules never conceived that a hearing can be conducted without the claims, the defenses, and the issues being carefully laid out before the parties and accepted by all of them before a hearing starts. Ladies and gentlemen, it is this total absence of compliance with all known rules of fair hearing that has caused my lawyers to file applications for judicial review in the High Court to declare all the proceedings void. Because the clear danger is that through this flagrant violation of CI 47 and the darkness of the current proceedings being held in camera behind the walls of a Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. And yet, the committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation for my removal on that basis. Allow me to say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out in the light of day. The final and fourth reason for this statement is that I have heard on several occasions from loved ones, persons who care, persons who may not know me beyond my public duties, and many who think that since these proceedings seem to be carefully staged to result in my removal as Chief Justice, it would be best if I just retired or resigned rather than subject myself to an ill-motivated process. I have also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I've also heard commentaries in the media about how this process was born out of a stated political agenda to remove me and control the judiciary, and that it is a political effort that can only result in an outcome that was decided long before it started. I thank everyone who has engaged in this conversation out of concern for my safety and well-being. Let me assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires will still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on. Therefore, if false claims are made against a judge or commissioner or other public office holder subject to Article 146 proceedings just to achieve a political agenda, the solution cannot be to resign or voluntarily retire out of frustration, pressure, or fear. You would only subject yourself to two cruelties: a judgment based on false claims and loss of everything you have worked for. It may well be that the efforts being made are intended to frustrate me so that I resign, so that the architects of the scheme can go back into the media and say that the wild and unfounded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. If I resign under these circumstances, I will be saying that this flawed, unknown, and opaque process is acceptable. It is not. Finally, let me respectfully say that the current bizarre proceedings I have brought to your attention present a twist to our nation's democratic journey that we all ignore at our own cost. My humble view is that Ghana has come too far in the 33 years of the Fourth Republic not to be concerned about the unconstitutionalities that have been designed not to affect just me personally as Chief Justice, but all judges and public officers subject to removal processes of Article 146, if this one is successfully carried out without being questioned. Behind me is every judge in the country. Behind me is every commissioner or head of an independent constitutional body in the country. If this is successful, it will be tried on anyone. I am not countering these processes for myself, but on account of the leadership burden that I carry. If the nation is willing to accept these developments in its democratic journey, it must be understood that I sounded the warning and the nation took the decision to be passive about it. I cannot share the burden of those involved in designing and implementing this enterprise of pretending to use Article 146 proceedings to remove a Chief Justice through unknown and unlawful means, by keeping quiet about the violations of law and due process. Neither can I make anyone's burden lighter by resigning or retiring, instead of proving that not even one of these wild claims in a collection of petitions is even remotely true or meets the standard required for removing a judge. Now, allow me to take you a bit of your time to walk through these petitions. They have been in the public domain for some months now. They are actually available on the internet, so I'm not addressing anything that is not known in the public space. Many negative things have been said about me through public commentary on the petitions, although the petitions were responded to 7 days after I received them. And so anyone who cared to acknowledge my side of the story would have had no need to keep repeating the petitions without discussing them with the answers. And when I provided these answers, I also added with evidence to prove that each allegation was either a lie, a wrong opinion about how work is conducted in the judicial service, a wrong opinion on the work of judges, or a wrong opinion on the duties of a Chief Justice. I'll start with Mr. Daniel Ofori's petition. It is a petition with the most claims. Only 2 out of the several allegations he's making involve him personally as a court user. In one of those allegations, Mr. Daniel Ofori is urging that I should be removed as Chief Justice because I transferred a case in which he's a party from one judge in the High Court to another. That is a crime. What Mr. Ofori did not seem to know, which I stated in my answer to that allegation, is that the judge his case was transferred from had a family crisis and had to leave Ghana suddenly for an extended period. This is the only reason why cases she was handling, including Mr. Ofori's cases, were distributed to other judges to handle. In the second allegation, Mr. Ofori accuses me of transferring a case related to the first one to the new judge who took over his case, after a petition had been sent to me to have the 2 cases heard together. Any lawyer or registrar could have informed him that it is a policy written into the rules of court to have cases between the same parties involving the same issue to be heard by one judge, so that we don't have different decisions from 2 judges on the same matter. So there is no basis or truth to the allegation that I transferred his cases to a new judge because I had an interest in his cases. Indeed, in the year 2020, I wrote a dissenting opinion in one of Mr. Ofori's cases in the Supreme Court. He won that application because my dissenting opinion was a minority opinion of 3 judges. The other 4 judges supported his application. After this, his lawyers applied that I should not sit on his cases again because I had presided over a different case involving him in the High Court when I was in the High Court in, I think, 2010, which he had also lost. Since then, I have not sat on any matter involving the gentleman. But what is disturbing about the current Article 146 proceedings is the fact that the cases that he is complaining about in the High Court, the ones that were transferred to one judge, started from a judgment in the Supreme Court written by His Lordship Justice Kwaman in favor of Daniel Ofori. How can Justice Kwaman, who gave judgment in favor of Daniel Ofori as part of a panel of Supreme Court and whose opinion I dissented with, which has made me a target of Mr. Ofori's anger, preside over processes to remove me as Chief Justice because of complaints that Mr. Ofori has? I have already protested that there is a conflict of interest for Justice Kwaman to chair the committee trying me or hearing me on Daniel Ofori's petitions. What Ms. Ofori's allegations seem to suggest is that a court user can attack the Chief Justice and ask for the removal of the Chief Justice if the Chief Justice does not agree with his case while sitting as a judge, or if his preferred judge is unable to hear his case. And now the judge who supports his case gets to preside over the removal process. Apart from these two allegations, Ms. Ofori has no personal interest in all the other allegations he's making. And he should not have been allowed to conduct a litigation against me under the disguise of an Article 146 proceeding. In two allegations, he's complaining that I misappropriated public funds to buy a ticket for my husband and my daughter to travel with me. In answer to this, I handed over my letter of appointment to prove that in my conditions of appointment as Chief Justice, Ghana graciously gave me 2 vacations in a year. In the Judicial Service travel policy, since 2010, the Chief Justice can never travel alone for security reasons, and the Chief Justice is always allowed to travel with a spouse or another person of their choice. So traveling on my officially given vacations with my husband on one occasion and my daughter for the second vacation is part of the official conditions of my appointment as Chief Justice. I was also not responsible for buying the tickets in question, such that I could be said to have misappropriated the value of the tickets. Indeed, if the Judicial Service was not allowed to buy the tickets for my vacation, the remedy was for the Auditor General to surcharge me to refund the money. Anyone can check out the 2023 accounts of Judicial Service and know for themselves that there is no surcharge against me or anyone for the tickets that were purchased for my vacations. Ms. Ofori seems to be alleging that I should have traveled with my police escort alone on vacation and not a family member. And this is why he wants me removed from office. And I'm being tried or held behind the walls of Edu Lodge. Ladies and gentlemen, the question to be asked is, why would anyone demand that I go on vacation given to me as Chief Justice with my police security, instead of going with my husband or my daughter? And how can this be a reason for subjecting a Chief Justice to a committee of inquiry? In the petition I received, Mr. Ofori also complains that my family members should not have been given per diem when they traveled with me, and I have misappropriated the per diem they were given. But anyone reading the Judicial Service travel policy will find that it provides that when the Chief Justice travels with anyone, whether police escort, another judge, secretary, or a spouse, that person is given per diem. And the rate of per diem is not set or administered by me as Chief Justice. It is regulated and administered by the Finance Directorate and the Judicial Secretary. I've already told you about the retirement of the imprest. In an arm of government where there are almost 8,000 staff that I oversee, Mr. Daniel Ofori's petition contains allegation that I transferred one member of staff to work on a different schedule, and that is why I should be removed as Chief Justice. He also alleges that I have refused to reinstate 2 members of staff whose appointments were terminated around 2015, 10 years ago, when I was nowhere near being Chief Justice, and whose issues are still being heard in court. He goes on to allege that I should be removed for terminating the appointments of 2 staff members who went through disciplinary proceedings that were initiated by reports against them before I became Chief Justice. Though it is not clear to me why Mr. Ofori should demand that the Chief Justice should be removed for transferring a member of staff or be the final authority to sign any termination letter, I handed over to His Excellency the President records covering every administrative step on these matters, supported by the due process administered by the right officers. And yet, without issuing a prima facie determination, a warrant of suspension was signed, and now I'm defending myself where there is no petition on the table. Another allegation of Mr. Ofori is that I appointed the former Judicial Secretary as Judicial Secretary when she was a judge, and so I have made her inefficient. Now, anybody who cares to know the records which I handed over to His Excellency the President was that she became Judicial Secretary in 2018. She became a judge in 2019. I was nowhere near being Chief Justice. I was appointed in June 2023. Ms. Ofori also alleges that I have appointed judges as registrars, and this has introduced inefficiency into the management of courts. Again, the records will show that the Judicial Council decided in May 2023, before I was appointed Chief Justice, that lower court judges should be appointed as registrars of the Supreme Court. So what I did was just to implement the Judicial Council's decisions. Then, Ms. Ofori alleges that a certain gentleman, not himself, but someone, who had a case in the Supreme Court in January 2024, met a different panel in May 2024, 5 months later, so I should be removed as Chief Justice. He also claims that I refused to fix an application in a case that did not involve him in Accra, which case was pending in Koforidua, so I should be removed as Chief Justice. He complains that I supervised the Judicial Secretary to administer a decision of the General Legal Council, which was taken before I became Chief Justice. So I should be removed as Chief Justice. If you read all my responses, you'll find that I provided all the records behind these decisions. Then he complains that I recommended judges to be appointed to the Supreme Court, so I should be removed as Chief Justice. Now, anyone who knows how appointments are made with recommendations from the Ghana Bar Association, the Attorney General, and the Chief Justice will know that this last complaint only shows ignorance of a very long-standing tradition. It has been the settled practice for decades that in the recommendation of justices for the superior courts, it is the Chief Justice, the Ghana Bar Association, and the Attorney General who have the privilege of making recommendations for those who are to be nominated. The recommendations can be refused or accepted by the President. I encourage anyone to read the judgment of the Supreme Court in the case of Ghana Bar Association and others versus the Attorney General, 2015-2016, to Supreme Court of Ghana Law Reports 872, when this matter was even discussed, and other academic works that discuss this practice that has been around for decades. How has it suddenly become unconstitutional or wrong conduct or incompetence for the Chief Justice to recommend to the President to consider for nomination judges who, in her view, satisfy the constitutional standard of high moral integrity? Yet, despite all the evidence provided, there is a hearing being conducted at Edu Lodge. I have taken this walk through Mr. Ofori's petition to show that the allegations have no bearing whatsoever on any sensitive national issues. or public safety or order, or my inability to perform my functions as Chief Justice. They also do not have any basis in law or truth. They are just an attempt to gather a lot of complaints together, regardless of whether they are true or not, whether they are justified or not, just to have an excuse for the conduct of this inquiry that breaks all the rules of fair hearing. I'll be done soon, don't worry. There's also a petition from a gentleman called Mr. Ayamga Akogo. His complaint is that on 14th November 2024, after the Supreme Court had given a ruling which went against him, I, as presiding judge in the Supreme Court, ordered his arrest without any reason. He attached an exhibit to his petition, which was a media report from a group called the Law Platform. This media report says that after the Supreme Court panel had ruled against Mr. Akogo, he started to shout in the courtroom, and that is why he was taken out of the courtroom. Essentially, therefore, his own exhibits contradict his claims. Mr. Akogo goes on to claim that when he applied for a copy of the day's proceedings, which were signed by all the judges that presided on his case, he did not see a record that he had been arrested. So I should be removed as Chief Justice. What is significant about this petition is that Justice Puaman sat with me as one of the judges who heard Mr. Akogo's case and was named as a witness that Mr. Akogo will call. But His Excellency the President has appointed him to chair and inquire into this petition, and he has accepted to do so. Ladies and gentlemen, Article 1273 of the Constitution indemnifies any judge against any action or suit for any act or omission by him while exercising judicial power. This provision was just last week cited as a reason for declaring a petition against a Supreme Court nominee frivolous. And yet, I'm supposed to be defending myself on the petition of Mr. Akogo for work done in the Supreme Court with 4 other judges. The last petition is from a group called Shining Stars. Searches have shown that no such group is registered in Ghana. Yet, it has petitioned against me, and they claim that during the hearing of the case of Afenyo Makin versus Attorney General and the Speaker of Parliament, when I sat as a judge, I failed to hear the side of the Speaker of Parliament before the Supreme Court made an order, so I should be removed as Chief Justice. Again, I can only point to the fact that no judge sits alone in the Supreme Court, and the court's decisions are the decisions of all the judges who sit together. So you will see that every decision I took that is complained about by Mr. Ofori, Mr. Akogo, and the group calling itself Shining Stars was done as a part of a panel of at least 5 judges that made up the Supreme Court. And all judges in the panel are indemnified by Article 1273. How tenable, if I can respectfully ask, can it be that a petition to remove the Chief Justice from office can be entertained on these grounds? Every administrative decision is supported by my constitutional obligations, and I have shown with exhibits, or I showed to His Excellency the President with exhibits, that each decision that was listed was taken after due process, and yet a warrant of suspension was issued against me without giving reasons. Interestingly, there have been some recent suggestions about rules being made to safeguard judges from frivolous attempts to remove them from office. It sounds like an attempt to assure the judiciary that after unconstitutional and illegal means have been used to remove me, conditions will be made safer for those who help with it or those who may be afraid by the current occurrences. Despite the interesting new discussions of rules for removing judges, I am convinced that it is only a matter of time for the nation's democracy to experience the bitter harvest of what I am reporting. And if this nation descends into the kind of proceedings behind closed doors that break all the rules of adjudication or inquiry as we know them, after all the progress that we have made in the rule of law, that descent will lead us to a place where no judge, commissioner, or head of an independent constitutional body will be safe from compromise created by fear, intimidation, threats, or a desire to please. A new standard would have been set where judges comply with what influential persons want or stand the risk of losing everything, including their career, their pensions, and their reputations through the smear campaigns that can accompany the process. Any petition will be enough to invoke the danger of being removed by proceedings that are not supported by law and which can be shrouded behind high security walls. I am confident that in my journey as a lawyer, as a judge, and now as Chief Justice, there is no one person in this country who can look at me in the eye and accuse me of taking a bribe to decide a case. This is the personal treasure of integrity that I live with. So what if these current proceedings are being carefully staged to result in my removal as Chief Justice, even if there's no lawful justification? All I have stated shows that any such action would have been done on the basis of lies and violations of law and due process. As a career judge who has served under 4 presidents, from High Court through Court of Appeal and Supreme Court, I could never have imagined such irregularities possible if I had not personally encountered them. I am also a mother, and I am a grandmother who must hope for better than this for our country, its rule of law, and its democracy. On my part, I chose to respect His Excellency the President's warrant of suspension, even though it was clear to me that it was not supported by a prima facie determination that is required by the Constitution and decisions of the Supreme Court. I have chosen to honor the process set in place to hear the petitions, but I do not choose to hide from the nation that perversion of law, rules, and due process, as we all know them, are driving the proceedings, and this renders the proceedings unconstitutional. I choose to trust that such darkness will not totally engulf this nation. May God bless our homeland, Ghana, and make our nation great and strong. Thank you very much.
The suspended Chief Justice delivering a fiery public address today, denouncing the ongoing proceedings for her removal as a violation of both legal norms and natural justice. Well, the Chief Justice stated that although she is the main target of the process, its implications reach far beyond court. She said this process affects commissioners and heads of states and other independent institutional body. She goes on to state that it undermines the very fabric of our justice system. She accuses the committee of inquiry of failing to follow the basic rules of due process, including not serving her with official copies of the petitions filed against her. And she goes on to quote that you cannot be summoned without a writ petition or complaint. I was not even given the documents to defend myself. And she went on to explain why. She says that the committee told her that the president had given her a copy of that petition, hence there was no need to provide her with the same copy. But she goes on to state that she can't verify both documents, and she stated that referencing constitutional instrument CI 65, which she claims were ignored. She goes on to state that the petitions, the earliest of which we know was filed on March 27, allegedly led to deeply personal intrusions, including a body search and denial of access to the chambers by her family. She has raised that same concern in her supplementary affidavits, which was struck out. While she also raised serious concerns about fairness and impartiality, pointing to a conflict of interest involving Justice Poamang, and questioned the integrity of the proceedings that allowed the petitioner, one of the petitioners, by the way, Daniel Ofori, to avoid testifying under oath. She goes on to quote that no rules laid out by the law have been followed so far, and that the process is fundamentally flawed. Well, when it comes to responding to calls for a resignation, the Chief Justice insisted that she is not clinging to a title or position, alluding to the fact that she's fighting tooth and nail, not for herself, but for the principle of justice. She revealed that she has revealed to us today that she received multiple threats urging her to resign, but she affirmed her refusal. She cited that not only is it her legal right to respond fully, but also the cost of her resignation is far-reaching. Let's go now to my colleague Michael Ashali on the grounds. He's just given us a wrap of some of the key things that have come up. Michael.
Rather issues that she's picked up with the committee that's supposed to be investigating the allegations made against her in 3 separate petitions. She's also responding to all of those allegations. There are quite a number of things that she's also raised here that we'll walk you through briefly. But the big question tonight, or this afternoon, she's answered. She's given us some sort of idea what exactly will happen. Is Chief Justice Gertrude Torkornoo walking off or staying to fight? She's giving us an idea. She tells us that this will rather be the bad time to actually walk away, given a years of experience, that should rather be in this exercise and fight. She's now greeting and laughing. The Chief Justice that was just serious minutes ago is now currently smiling at the moment here. So I'll quickly walk you through some of the things that she has been saying tonight, starting almost all from the violations that she says that she has observed right at the committee level, will be that the committee's refusal to allow her some of the things that she thought as a lawyer in a practice over the years have been basic to the work that she does. She says that there is a breach of the rules of natural justice to recognize my counsel on the first day of proceedings simply because I was not personally present. Again, she goes ahead to talk about where the venue for these proceedings, that is the committee that is looking through the allegations against her. She thinks that the place again, sort of a subtle warning to her that, well, we are here to only remove you. She says that she's not been given enough opportunity to respond to specific claims. She says that although that she was written by John Dramani Mahama, who is the president of the land, she hasn't seen any official petition at the committee level that has been submitted to her as well. So as it stands now, she is riding blind and has to defend herself, not knowing what specific allegations again are at the committee level. She goes on to talk about the fact that no citizen in this country can be summoned without being given a writ of summons, a petition or complaint. She says that it is also the duty of every court, committee or tribunal to give anyone summoned before them copies of all documents that have been filed with them before the hearing. She says that this has not been done. Now, she says that I gave the committee, I'll take it from here. She said the Article 146 committee that is hearing the petitions at Adu Lodge has refused to give me copies of the petitions that His Excellency the President set up to inquire about or into the responses I gave in the prima facie determination that His Excellency the President is supposed to have made. They claim that they know that the President sent her copies on the 27th of March in 2025, but do not or will not show her copies given to them. This is one of the things that she thinks that are a breach of natural justice. Again, she says that the committee told her that they will not prepare a hearing bundle or direct the registrar to serve her with documents that the President has referred to them to inquire into. That's more. She also talks about the decision of the court to, or the commission or the committee to run as a litigation rather than as a committee of inquiry. In that statement, she says that in the Commissions of Inquiry Rules 2010 CI 65 and in Article 146 Clause 7, if the committee is set up it's supposed to inquire into the petition, the answer, and the prima facie case. In spite of this, on 15th of May, the committee indicated that it will not conduct the hearing, quote, not as an inquiry, as directed by Article 146 Clause 7, but as a regular litigation. The committee, she says, rejected the use of CI 65, which is created for the conduct of an inquiry, and stated that they will rather use the High Court, which is the Civil Procedure Rules 2004 CI 47. She concludes on that issue of the decision to go the litigation way that the committee decided that each petitioner is to conduct his or her own case as they deem fit without presenting a petition to the committee or testifying on oath. The petitioners will be allowed to issue subpoenas to public officials as witnesses to confirm what they themselves do not or has not testified to. She goes on to make a number of other things, but just if you are just joining us on Joy News, a few moments ago, Chief Justice Gertrude Torkornoo, the very much embattled Chief Justice of the land, has been responding for the very first time, unprecedented, speaking to the nation about the breaches she feels have been committed or made in the last couple of weeks and months since John Dramani Mahama suspended her after he received 3 petitions, which he also forwarded to the Council of State, that found prima facie case for her to be asked some more questions. The committee which has been set up has also been embroidered in a lot of litigations, and we know that at least 4 cases has gone to the Supreme Court in the last 3 months, trying to also halt the process. The last of which we know was filed by the Chief Justice herself with a supplementary affidavit that were making some allegations of how she's being mistreated at the committee level, and some of which she has reiterated today. She's also taking some good time to be responding to the 3 petitions and the specific allegations they make. There was one that talks about, that alleges that she, the Chief Justice, had caused the arrest of one of the petitioners, and the petitioner feels that that is enough grounds to call for her removal. She has been responding and says that at the time of making that decision, the petitioner at the time that was in the court was making some noise, and she was forced to make that decision to ask the person to be removed from the court. Again, she's also responding to allegations of financial misappropriation, that not accounting for some impress that was given to her on international travel. She says that certainly is not grounds or any legitimate grounds for her removal, because upon her arrival back to Ghana, some of these monies which were not spent were returned back to the state, and she has copies and has given some of those to some of those who care to find out what exactly has happened. But all of these, she says, has fallen on deaf ear. But rather than leave after all this barrage of her own concerns and things that she's noticed at the committee level, she will stay and fight the process to the very end, given that she herself as a lawyer and as a judge and now as a Chief Justice believe in testing the law and also dealing with it and make sure it comes to a logical conclusion. And that is exactly what she's going to do at this moment in time. She's going to stay and fight to the very end.
Thank you. My colleague there, Michael Ashali, just giving us a wrap of some of the key things that have come up today. I still have with me my guests on Zoom. I have with me the former Deputy Attorney General, Alfred Chiayebwa. We appreciate your time on phone. I have with me Anza Sari, former Director of the Ghana School of Law. I'd just like to pick their quick reactions. I'm quoting her. She says the violations have not stopped. They have escalated. Your reaction?
I think I also listened to her carefully. And before she even spoke, I think we had earlier on discussed, and I made reference to violations, be it human rights or procedural violations. And per her statement, there are still violations going on before the Committee of Inquiry. And the essence of this media encounter is to bring out those violations. She has listed a lot of them. And I think if these allegations are true, then we may have to look at the whole process again. And I also listen to respect to the procedure being used, whether it's a committee of inquiry or they must go by way of litigation. But it's also a very funny issue. I also heard her speak about the intention to also go to the court to quash the whole proceedings. If that's also the case, then perhaps there can also be an avenue. My personal view is that whether you are being tried under Article 46 or whether you're being tried under any other provision, your fundamental rights ought to be respected. And I cannot understand how a suspended Chief Justice, she's not dismissed the Chief Justice, will be subject to a search when she's going to appear before a committee of her peers. Two of them are the two of them Supreme Court judges. She also raised issues about conflict of interest.
Yeah, with Justice Palmang, she raised that concern about conflict of interest.
Yes, because if the allegations are true, that Justice Palmang was part of the panel that sought to, as it were, discipline that lawyer, then I do not see how she can be part of such a panel that's trying to inquire into whether CJ should be removed from office based on such a decision that she took. We've also looked at the case of the gentleman that said Justice Palmang also gave judgment and she was part of the minority. And now if that's the basis of an allegation for her removal, I do not think that if I were in shoes as Justice Palmang, I would not sit in such a procedure.
So you feel that he should recuse himself? Well, whilst
and the other judge, you can also sit on the matter.
We have you back now. We lost you briefly. So you want him to recuse himself from where you sit? That should be the right thing to do?
If I were him, I would do it. Because after all, he has nothing personal in this matter. And there are equally good judges who can also sit on this matter and come to a conclusion. And then perhaps, because so far as these issues are raised, you may have every genuine intention. But at the end of the day, if a decision goes against the person raising the allegation, then the impression is that because you had an interest, that's why matter went against the person raising the allegations.
Okay, let me bring in Martin Pegbo at this time, a counsel, just to get his thoughts on some of the key proposals that have come up this afternoon. Now, she's accusing the inquiry committee of failing to go through due process. One key concern she raises is the breach of that CI 65, which she says that they failed to provide her copies of the petition, and that, a prima facie case that has been determined against her. I'd like to start with your thoughts.
What we can say is that, you say, because Article 146 says that the proceeding should be in camera, generally, it's been opined that most lawyers agree that, and also the Supreme Court has agreed, that we can't discuss these petitions, etc., into details when the committee hasn't finished the hearing. Okay, so in the Frankie J. versus Attorney General case, the Supreme Court said what is permissible is that when the petition is filed, the petitioner can disclose to the media that I filed this petition, but don't go into the details and the merits of it. So now the Chief Justice has done so. The law is still evolved. Well, the law may evolve, but at least what I know is that generally lawyers are agreed that we can't go into the merits, into the details. This is not the first time this argument has come up. Not the first time, but in terms of her case, you remember a few weeks ago, she waived her right to the secret hearing, that's the in-camera hearing, and said she wanted the proceedings to be telecast, broadcast. But we were generally agreed that if you read Article 146, okay, you would see that it's supposed to be in camera, meaning secret. So I then went ahead to say the only time we can change, and generally people disagreed, and so I'm no longer making that argument, but I'm just showing you the history. So what I said at that time was that, well, if a polls could be conducted, and then if the polls show that majority of Ghanaians want it to be done live, then broadcast for people to follow, then we could consider doing so. But as I mentioned, democracy is crowd wisdom. Lawyers and non-lawyers alike all came down that no, what I was supporting the Chief Justice, and they said no, they don't think so. Because some even said if you did that, then the Chief Justice could later even file to say what was done was in breach of the Constitution. So what I'm saying is that as a society, this debate about, let's discuss the merit, let everybody see what's going on, has already come on, and then it was decided generally that nobody should do broadcast. And so if you say don't broadcast, don't let people follow the proceedings publicly, because it is against Article 146, clause 8, then it means that what the Chief Justice is done today, if we were to join in discussing the details, I will be found wanting again. So for now, let's not go into the details. Maybe if later superior arguments come up that show that we should go in, why not we'll go in? But
okay, even though you don't want to go into the details, she has raised key concerns about the consistent violation of her right. You are a human rights champion. We know that. Is that not enough grounds to pull the brakes on this process entirely?
No, not that I'm aware of. So what lawyers will tell you is that, so for these violations, then she has to wait till the end of the hearing, okay, or the trial. Then she will file what we call judicial queue. Yes, so she's allowed to go and say she wants to pass. Or while the proceedings are going, she's allowed to go to court, like the way apply for person in court, to set aside whatever is done. And she's allowed to. But I am not allowed to go ahead, join in doing this discussion. You see, one thing is very clear. It appears that going into our new constitution will not have the current proceedings being blanket in camera hearing. Some parts will be made known to the public. And I'm happy even the chairman of the Constitution Review Commission, H.K.C. Prempe, has said he's in favor of certain parts being disclosed to the public, etc. So there will be a much improved version in the new constitution. But, well, the new constitution is not ready. So the one we are using now, we cannot go into those aspects, not now.
Stay with me, Martin People. Let me bring in former director of the Ghana School of Law, Kwekwa Sansari, join us live here on the Pulse. I just want to pick your thoughts. The Chief Justice, suspended Chief Justice, is for the first time speaking. She has raised concerns about how she's been treated, violating her rights. That's how she puts it, as to how the committee is going about their work. I'd like to pick your thoughts on this. Is that not enough grounds to pull the brakes on the process entirely?
Thank you very much. I don't think that whatever concerns Chief Justice has push her into what she has just completed. You see, a Chief Justice is a Chief Justice. She is the boss of all the boards, where ordinary litigants will attempt to seek justice. Now, if the citizens are saying that they have no confidence in the judicial system, and the Chief Justice supports them by saying that he also does not have confidence in her own delivery system, and it means that the bastion of democracy was assured. She's frustrated, I can understand. And I accept the sentiment. But this is not the solution. What she has done is to prescribe a drug that is, supposed to cure an illness.
But she argues that the natural laws of justice have been breached. Isn't she right to raise concerns if she argues that the natural laws of justice have been breached? For example, she says that the committee failed to even provide her with the petition or that document that proved that indeed a prima facie case has been determined against her.
Whatever constitution he has to go back to the committee and voice them out.
The same committee, she's raising concerns about the constitution of the committee. She's raising concerns about the chairman of the committee, that in fact he's embroiled in conflict of interest, Justice Poamang. How can she go back to a committee that she doubts the credibility of the leadership?
It is not, you see, the Article 146 process is presidential and deeply rooted in the Constitution. It is not for the members of the general public, to take part in the process. That is why the proceedings are constitutional to be held in camera. If it had been otherwise, I'll share, what she has done with them. But here we are, the Chief Justice, who knows or ought to know that when proceedings are held or being held in camera, you do not rush to the court of public opinion to say or tell your side or version of the fact. No, it's untenable. He is the chief of the justice delivery system. He must go back to the committee and whatever concerns, express them to the committee. He can articulate frustrations against Poamang before Poamang and let Poamang report her. He should insist, the lawyers must insist, we want you to record whatever our client or the party is saying, but not to say to a press conference and say her frustrations and then expect the public to support her. The public is not the president. The public is not the president. The public cannot lift the suspension. The public cannot terminate the suspension. It is only the president who can lift the suspension in accordance with the processes laid down. It is not for the public at all. I disagree with this approach. I think I will repeat what I said some 2 months ago, that she keeps shooting herself wrongly in the foot. This is yet another instance of a wrong approach of amusing Chief Justice. She's so frustrated. She's taking, to the public and sucking up. So she's talking up now to the populace. I'll roundly condemn her that the Chief Justice must not do that. She should wait. And if the process terminates, then she can let the public know what has transpired. She can appear 1 million times before the public. Is not going to influence the value judgment. The value will remain the same. She has been suspended. We believe that the process is, constitutional. Once the process has the support of the Constitution, let us abide by the constitutional pathway that has been charted in the Constitution. Article 146 has been triggered. If it is not going well for her, let us finish. The review committee is there, will support the committee to take a second look at Article 146 and see, how best we can all mend, what we find wrong with Article 146. But this is not one of the processes, that can result in the amendment of Article 146. I'm sorry.
But she also served notice she'll be challenging this process entirely in court. What's your thoughts about that route?
You said what?
She will be challenging the process in court.
She has challenged 5 times and been bound 5 times. A 6th time, it is not the quantity of applications that will determine the final verdict. It is her appearing and putting her case across to the committee. If you listen to her carefully, what she's saying is that the grounds are, baseless, and therefore the whole thing to be thrown out, as being wholly unmeritorious and with, lacking in legal merit. If that is so, let her, push the thing through, and in a final state to the committee, tell them, to their individual basis, that the whole thing lacks merit and should be thrown out. That is what I expect a chief justice to do, but not to, run amok to the public and seek solace there. We cannot help. The only person and the only entity that can help is the Constitution.
But isn't it concerning that the committee failed to give her copies of the petition? And their argument is that the president already provided her with a copy of the petition for her to respond to. Is that standard procedure?
Well, if the committee fails to give her a copy of the petition, is the committee's petition different from the petition the president forwarded to her? Is the committee's copy different from the copy the Council of State examined? These are frustrations of someone who has been wounded, and once she feels wounded, she'll be holding on to something. I'm suggesting to her that she should not involve the general public in this messy affair. She should stick to the constitutional pathway. What the Constitution expects of each chief justice, the head of the third arm of the government, which is responsible for protecting the civil liberties of the individual as enshrined in Chapter 5 of the 1992 Constitution. She must not photo to pressure from a few disgruntled people who are ill advising her. She should take wise counsel from the Judicial Council. That is, why the Judicial Council has been established to advise her on how she should behave herself in public, out of public, with regard to aspects of the law, because even though the law lies in her bosom, if she feels wounded, to be overlooking the correct and appropriate legal category. In that, when in such a situation, is bound to slip fall, which is not in her own interest. I don't think that she should repeat, this thing again. It's not in her interest. The chief justice must not do that.
Mr. Sansari, stay with me. Let me bring in Afetia Yeboah just to get his response. We've been hearing from Mr. Sansari. He says that the Chief Justice approach is wrong. Your thoughts on that?
I disagree with Mr. Sansari. Maybe he's not followed the proceedings. Here's the case that the Chief Justice filed a supplementary affidavit to a suit at the Supreme Court detailing some of the human rights violations that she was undergoing at the time. But the Supreme Court in this ruling said, because the matter under Article 46 is heard in camera, she could not complain outside the committee. And I said, I find it, something that I cannot understand. And so if you have a client who has been told that even if your rights are being violated, you cannot come out to complain, what do you expect such a client to do?
He's
Maybe
proposing that the client should go back to the committee and table your concerns to the committee.
And if the committee, but what's the evidence that she has not even tabled these concerns before the committee? Definitely, CJ, as I know, is also an experienced person. But the thinking or the view that whatever happens there cannot go out is what's pushing her to the media. Because now it's as if you go there, with all due respect, they tell you to even strip naked against your fundamental rights. You cannot come out to complain. And if you have a client who is undergoing such a process, what do you expect such a client to do? My thinking is that when it comes to human rights violations, the courts must be prepared to step in, provide us evidence of violations. But if you are to shut the door to parties who are undergoing Article 146 proceedings, then we have this instance that we've seen this afternoon. The parties or those affected, they want to come out and state their frustrations.
She said that she received multiple threats urging her to resign, but she's willing to fight this out in court. But this is the same legal system that she's raising concerns about. What do you make of the fate of the case she may file in court, looking at the precedent that previous cases have already been squashed?
I will encourage her to so explore the legal process. If her lawyers are going to court, she must go. I will not take the route of Justice Sansari is saying that if she goes, it may be dismissed. I mean, as a lawyer, I will not speak that way because facts are not the same. You may present a set of facts to court, the same court. On another occasion, different facts may be presented, and you may have different results. So as a lawyer, I will not advise any client to say, don't go to court because your case is going to be dismissed. So if she's going to use that method in addressing her grievances, I'd rather encourage her to do so.
But then let's look at some other key concerns she raised about the other committees that have been set up to look into the petition. The other petitioners, I beg your pardon. She raised concerns about the group that has been set up to look into the petition, that actually submitted the petition, I beg your pardon, some Shining Star group. She says that based on her checks, the group does not even exist. Is that enough grounds for them to squash that petition?
I'm not going to prejudge whatever the committee is doing, but this is her defense. This issue is definitely considered by the committee, and the committee may evaluate it and come to a conclusion on the matter. Because when it comes to the hearing of such matters, it's expected that persons who submitted petitions must have a standing, whether it is a natural person or artificial person. And so from the CJ's point of view, one of the parties or one of the petitioners has no standing. That one should be left to the committee to determine.
I see. We're just getting your thoughts and reactions here on the polls. The Chief Justice, suspended Chief Justice, has for the first time addressed the media on the 3 petitions levied against her. She has raised key concerns about the breach of her human right, and she has also raised concerns about the constitution of the committee and key individuals on the committee. And we're just getting your thoughts on that. You can share your thoughts with us on all our social media handles. We're Joy News on TV. Let me come back to Ansasari. We've just been hearing from Alfred Tuyayeboah that the legal route is the best option. You feel otherwise?
The infractions or violations of fundamental rights on a question before a committee established under the Constitution are not within the province of the public. You see, so if she has any worries at all, she must express the worrying concerns when she appears before the committee that has been set up to go into the petitions or allegations, purporting to seek a removal. She's been suspended. She has not been removed. She has not been accused. Or it is somebody or the 3 people who have petitioned who are making allegations. And the principle of law is that he who alleges must prove, not he who denies. Therefore, it is not for the Chief Justice even to prove, her guilt. It is up to the petitioners to prove their case. If they are not able to establish their case, then the petition will be refused. I think appearing before the public to do what? To do what? What can the public do? So this is only a court of public opinion. That is why it is referred to as a court of public opinion. And in matters of law, he, the Chief Justice, ought to know that as a judge, she is not to listen. She must be trained to protect herself. I mean, rushing to the general public, walking up to the general public, to court their sympathy is not the way to go. The way to go is to cooperate with the committee. And if she feels that she is not getting the justice she, expects, she reasonably expects, let her wait. She must do her case. One day, the proceedings will come to an end. And if after that, she has any further objections, she can then take those objections to the appropriate forum. But appealing to the good conscience of the general citizenry is contrary to the judicial oath that she subscribed to on her appointment either as a justice of the High Court or to the high office of Chief Justice. Either way, she must respect her oath. And I'm glad she said that she has absolute trust in what the president has done. So if she is, being frustrated, she should not, take to general public to express her frustration. She must just cooperate and bring this saga to an end. That's all that I'm saying.
But then the outcome of this whole process has far-reaching implications, especially for the legal service and the judicial service. The reason why she wants to fight now, just in case she loses her seat, because she already alluded to the fact that you cannot wipe away the fact that there are political undertones in this.
I mean, if this is a science, it becomes a body. The body is not, is one who, take matters upon himself or herself, to fight, for a system unsolicited. The general public has not, appointed, as their counsel. She must fight for herself. She must, act in accordance with the law. She must always remember that she is the Chief Justice. Although, she has been suspended, she remains the Chief Justice. So when she addressed the media, the tag was not suspended Chief Justice. They say, the Chief Justice speaks to the nation. And I'm glad she has done that. But my advice, the caveat I'm sounding, is that she must not take this case to the court of public opinion, because under her watch, this, happened, that her photograph will appear in the paper, the disgruntled litigants, and aggrieved litigants appealing to the Chief Justice, for mercy. Now, if she will now, descend into the arena of the court of public opinion, it is, signaling a very dangerous precedent for the whole nation. We will come out losers.
Mr. Asasari, permit me to come in at this point. I have to take you live to the presidency because there's an official address ongoing. The presidency is about to address the media. My colleague Maxwell Agbagba is on standby just to give us a sense of what we should expect. Maxwell, take us away.
Yes, Faustina, like you rightly mentioned, the presidency has been monitoring that press conference addressed by the suspended Chief Justice. And I can report from the presidency here at the Jubilee House that all is set. In fact, the government spokesperson will be addressing the press conference shortly. In a moment, as you can see, the set is being prepared for that conversation to take place here at the Jubilee House. And I can report to you that the press corps here at the presidency have actually been on standby in waiting to know what the press conference was going to be about. But now it has become absolutely clear after that press conference addressed by the suspended Chief Justice. Now we know that the presidency will be responding directly to the press conference that was held less than an hour ago. You can't expect that government will respond to the allegations of fear and intimidation as leveled against the government by the suspended Chief Justice. You can also expect government to respond to the specific allegations regarding some of the petitions that were presented to President Mahama. You know that the presidency has always held that this process has been, held in a fair and transparent manner. Many government officials who've been speaking to, many people here at the presidency who've been speaking to, believe strongly that this whole judicial process has been very transparent and in fact has gone through every process as stipulated by Ghana's constitution. So for the presidency, it holds the view that it has not breached any any process, any step in this judicial removal, process. So we're waiting for Felix Ofosu-Kwakye, who is the government spokesperson, to address the press and then respond directly to the claims made by the suspended Chief Justice. So we're waiting with bated breath here, and we're waiting to hear his response to all the specific allegations made by the suspended Chief Justice, Faustina.
Well, Maxwell, I know that at the presidency, they watch Joy News, the most trusted news source. So what has been the reaction so far when they had some of the key concerns being raised by the Chief Justice? Talking about the whole process, she feels that her rights have been violated. What were their responses when they saw her making that emotional statement today?
Well, Faustina, as it stands now, we've not had any official comments, coming from the presidency. And some of the people we've been interacting with are unofficial sources. But I can tell you that as we were walking into the presidency, all the television sets here were glued, listening and watching, the press conference that was being addressed by the Chief Justice. So many of them were following the press conference, and they followed it to its end. But what I can say is that we do not have any official response from anybody here from the presidency. But some murmurings and comments that we've been hearing from unofficial sources and some of the people who we've interacted with here have been saying that they believe that the process so far has been fair and transparent, and that the suspended Chief Justice may possibly be killing an ant with a sledgehammer with that press conference, that she held. Also from some unofficial sources that we've heard commented on this particular issue, some also think that she may possibly also be in contempt. Remember that the Constitution indicates that such processes must be held in camera. It doesn't have to be out there, and they feel that the Chief Justice coming out fully at a press conference like this, addressing the press and possibly revealing some of the processes that she's going through may amount to contempt. But once again, these are comments from unofficial sources. In some minutes, we'll be hearing the official, response from the government, from the presidency on that matter. And like I stated, we are all waiting with bated breath to hear what the government spokesperson, will be saying.
So we're keeping our eyes there at the presidency. Just like you've told us, Felix Kwakye Ofosu will be addressing the media shortly. And we're keeping our tabs on it, on your screens now, live visuals from the Flagstaff House, as we're just looking at what we should expect is some visuals. And then if you're just tuning to the Joy News channel, the Chief Justice, suspended Chief Justice, has for the first time been speaking to the media about the whole process for her removal. Now, she revealed that she has received multiple threats urging her to resign, but she maintains that she's going to fight this tooth and nail. And then let me just run you through some of the key concerns being raised by the Chief Justice as we're awaiting that news conference from the presidency. She goes on to state that all the events to have me removed as the Chief Justice has been staged. She goes on to state that the efforts being made are intended to frustrate me so that I resign. And she keeps hammering on that. But then we're just hearing from Maxwell the little undertones and talk going around this whole process. We've been hearing from Ansar Sari, who felt that she ought not to have addressed the media because the process in itself is held behind cameras because of the concerns being raised about the quantum of allegations and what this would mean for the judicial service. Is she in contempt of the whole process? That's a conversation we'll be having. Alfred Tiaibwa is still with us here on the post. I just want to get his brief thoughts on that. Knowing that this process ought to be held behind closed doors, what are the implications for her holding this news conference? Will she be in contempt of the whole process?
I do not think that should be in contempt of the whole process. Because in the Itaderi case, the Supreme Court, in fact, there was an issue about the leakage of the proceedings. And what the Supreme Court said was that in such situations, it will not affect the proceedings. It will not void the proceedings. And so if we are now discussing this issue in the public, I don't think the CJ or the suspended CJ could be held in contempt of the committee.
Now, just before we had to take that break, I wanted to pick your thoughts on some of the key concerns that she has raised, especially with the political undertones that she alluded to. This process, from where you sit, is it all a political, challenge, really, just to take her off the seat?
Before the elections, we had issues regarding the opposition party then promising to do something about judiciary. One of the things they promised to do was to remove the Chief Justice. And so now she's saying that she's also read and heard that these things were with regard to the actual performance of her functions as the Chief Justice. If you look at the petitions, fine, I've read the petitions, I've listened to the content, I cannot see any of the grounds which is weighty enough to merit the removal of the Chief Justice. But we are here now. That's what we are all waiting to hear, whether the committee will come out to say that based on the petitions, 3 petitions, the CJ should be removed from office. And I'll be surprised if the decision is reached.
But based on the 3 petitions from where you sit, is it the case she is making right now that there's really not enough grounds in these petitions, enough reason for her to just sit quietly and go through the process?
She doesn't have to sit quietly and go through the process. She denies the allegations contained in the petition. She has responded to the petition. But in the course of the hearing of the petition, if there are issues, she reserves every right to complain about those issues, specifically if there are human rights violations and violations related to procedure. And as to whether the committee may accept what she's saying or not, we leave it to the 5-member committee to look at it. But I want to make it clear that the CJ is first and foremost a citizen of Ghana who has the right to also engage in any kind of free speech. That one should be there. The CJ is also a Ghanaian who's entitled to fundamental rights. The fact that she's been removed through at the 146 proceedings does not mean that her rights as a citizen are ousted.
But then You've raised a salient point there. Why not walk away? If you feel the petition is baseless, if you feel that the committee set up to probe the allegations have been compromised, especially because you raise concerns about the presence of Justice Pwamang, why not walk away entirely? What's in it to lose?
Why should she walk away? She must rather fight on. If despite her defense, the committee comes out with a decision, that decision will be there for all of us to see. And then the future, moving in the future, at least we can look at that decision and say that this decision is either good or bad or whatever. But what I'm saying is that the CJ is someone that I know. She's very much convinced that she has not done anything untoward. Allegations have been filed against her in the petition. She's defending the petition. At the end of the day, there will be a decision from the committee. But if she walks away now, what's the implication? It means that all those allegations are true.
And on your screens, we have live visuals from the presidency. On your screens, you can see Felix Kwakye-Ofosu about to address the media. They will be officially responding to some of the key concerns being raised by the Chief Justice, and we'll be taking you there live once it all begins. What are your expectations? Just seeing Felix on the screens, what are your expectations for this news conference?
Actually, I do not have any expectations from them because the CJ addressed the media, raising certain issues. Maybe they are here to speak on behalf of the committee. Okay. I don't know whether that's, but let's wait and see. Otherwise, I do not see how they can respond to those issues raised by the CJ because they are not directed at the presidency.
Okay, but let's look at the implications for the judicial service, having this whole issue out in the public domain.
They are out because people decided to leak the petitions. They are out because when an attempt was made by the CJ to complain about her human rights violations, that attempt was shut down. Per our constitutional architecture as we have it now, as you rightly indicated, they are all supposed to be held in camera. But we've been having some of these petitions, not this specific one, earlier ones, come into the public domain for people to discuss it. I think it's something that we need to look at moving forward.
It's something that we have to look at moving forward. Do I still have with me Ansar Sari just to get his final thoughts as we're preparing to cross over to the presidency? Felix Kwakye-Ofosu is on standby to address the media. The Chief Justice, for the first time, suspended Chief Justice, has addressed the media. It's the first time we're hearing someone with her position talk about key concerns that is affecting her. Let me take you now live to the presidency to listen to the official response to this news conference.
Many of you in the media have reached out to me seeking to inquire about what government makes of the press engagement that her leadership, the Chief Justice, just had, which bordered on the petitions brought against her and the deliberations of the committee tasked to look into the matter. Ordinarily, if the matters were left to the content of the petition and the processes being undertaken by the committee, we will not have cause to comment because those are matters beyond the purview of the president or the government. But a number of things were said at the media engagement that, if left uncorrected, could create an erroneous impression and project government in a very unfair, unjust, unwarranted light. To begin with, we respect the right of her leadership, the Chief Justice, to express any view that she holds about the matter in question, to the extent that it is consistent with the rules, because the Constitution makes it clear what the processes are in determining a matter of the sort that we are engaged with. The Constitution requires confidentiality on the part of all parties. It is a reason why the presidency, on behalf of His Excellency the President, has refrained from commentary on the matter beyond stating what the President has done in compliance with the Constitution. So it would have been desirable that that constitutional provision was respected by Her Ladyship the Chief Justice, so that we do not have to engage in public commentary up until the time that the committee looking into the matter makes their determination. We are compelled, however, to correct certain misimpressions that were created at the briefing. To begin with, let me point out that as yet, nobody has been able to ascribe any known verifiable constitutional breach to the President in the way that he has handled this particular matter. From the very first steps in this matter, the President has kept fidelity to the Constitution and has respected the spirit and letter of the Constitution. Everything he has done has been by the book. That is why all those who have commented on the matter, including Her Ladyship the Chief Justice, have been unable to point to any specific provision under Article 146 that the President has been in breach of. Second, in terms of confidentiality, the President has acted strictly in accordance with the Constitution. At no point in time has the Presidency put out anything in any way, shape, or form that remotely resembles any of the contents of the petition. And the only communication that has gone out on this matter have been about the steps that the President has taken in accordance with the 1992 Constitution, Article 146 to be precise. 3, Her Ladyship the Chief Justice all but insinuated that there was some political agenda at play to oust her, and that this whole process is a result of same. Let me place on record, without fear of contradiction, and let me be clear that no such political agenda exists. His Excellency the President took an oath to which he was incidentally sworn by Her Ladyship the Chief Justice herself. And in that oath, he swore to abide by the 1992 Constitution. He is enjoined to act a particular way when he receives petitions of the sort that he has received. And that is all that His Excellency has done. He has had no choice in the matter. The President cannot say that he has a view about how things should be done, and therefore, if petitions have come, he will fail to act. If he did that, he himself would be in breach of the Constitution, and therefore, he has been enjoined to act as any responsible leader or President of the Republic of Ghana would be required to do, as stipulated by the 1992 Constitution. The fourth point is also that we cannot have a sacred cow mentality in the way that we handle state affairs. Every single public official, from the President to the Speaker, to the Chief Justice, to Supreme Court judges, to ministers, to all public office holders, are bound by the provisions of Ghanaian law. Indeed, it was the former Australian Prime Minister, Kevin Rudd, who once said that when you join the game, you play by the rules. So no public official is allowed to raise him or herself above the laws of Ghana. It does not matter how sensitive your position is. Once Ghanaian law dictates that certain processes be undertaken in respect of some alleged misconduct, the rules must come to play. And that is the only guiding principle that President Mahama has operated by in all of this. So any claim, any inference, any innuendo, any imputation of a political motive to the president in respect of these processes are unfounded, they are false, and cannot be allowed to stand. And I wish to place that on record. As yet, absolutely no evidence of same has been furnished in any way, shape, or form. And therefore, I am minded to strongly reject that effort. Unfortunately, Her Ladyship, the Chief Justice herself, has added to this commentary, which initially was the tone of elements of the opposition. And it is deeply regrettable that this should happen when the president has been above board and conducted himself in strict compliance with the Constitution of Ghana. The other point that I wish to also place on record is that the attempts to link the dastardly killings of some Supreme Court judges and a military officer to this case are most disingenuous. To begin with, this government and President Mahama have nothing to do with the killing of any judge. Second, there's absolutely no nexus between the petitions that have been brought and that unfortunate incident in our past. So any effort to link the two is regrettable and should not find space in this sort of discourse. It is most undesirable, it is most unacceptable. Now, the venue in question is the Edu Lodge. Yes, it is close to the Osu Castle, which used to be the former seat of government. As I speak, there are government agencies that operate there. So it is a public place. The Osu Castle is a public place. You can go there to conduct official government business. Beside it are private residences owned by Ghanaians who move freely in and out of their residence, even though they are situated very close to the Osu Castle. So the impression that a facility in the vicinity of the Osu Castle necessarily makes it intimidating or foreboding is completely misplaced. It is unfair. It is not justifiable. Now, Edu Lodge is a state facility which is often used to house high-ranking officials who visit the Republic of Ghana. It belongs to the state. The decision to use that place was not that of government or President Mahama. The committee requested that they needed facilities of a certain status that could house their activities and that could facilitate a smooth running of the proceedings. And that facility was available. It is equipped with modern amenities that will facilitate the work of the committee. And the state only offered it upon the request of the committee. Let me also state that that facility is not intimidating. It is like any regular state facility where business can be conducted to the extent that it is put in the right shape. Wherever these proceedings were held, it will still be in camera, as clearly stipulated in Article 1468 of the 1992 Constitution. So that the proceedings are being held in camera is only in compliance with the Constitution. So it doesn't matter where it is held. And any security measure put in place is only intended to secure the place so that persons who are not authorized to be part of the proceedings do not come there and create any inconvenience. I believe that even if the hearings were held at the court premises, it will still be under significant security controls to ensure that only authorized persons have access to the place. So to describe Edu Lodge in the terms that Her Ladyship, the Chief Justice, did was most unfair and unjustifiable. It seeks to obscure the process and bring in unrelated matters that seek to cast some aspersion or ill motives on government for affording the committee a place to do its work. As I indicated, we have no interest in violating the Constitution by going into the merits of the case. And that is why government has refrained. Let me put it on record that government itself has had cause, indeed the president himself had cause, to lament the way in which some correspondence around this matter got into the media. You will recall that the very first sign of any leakage was the letter that the Chief Justice wrote requesting for copies of the petition. Before the letter got to the presidency, it was in the media. And you recall that in the president's response, in which he also took the opportunity to forward the petition to her, we raised that issue, that it was not acceptable. Indeed, the president had cause then to ask his executive secretary to mark the documents that were being sent to the Chief Justice in order to guard against any leakage. So at no point has anybody leaked anything. Also, it must be noted that even the media houses that first broadcast the content of these petitions were media houses that you can say are aligned to the opposition. And they are the ones who have gone to town with this sort of thing. So to attempt to cast aspersions on the presidency is most unfortunate, and it causes what should be a smooth process leading to the determination of the merit or otherwise of the petitions that have been brought. So in summary, I would say that what has happened today is most regrettable. And as government, or as the President Mahama is committed to upholding the rule of law. We cannot have a situation where, depending on who is involved, the constitution is set aside. All Ghanaians are equal before the law, in the same way that our courts have dealt with individuals in accordance to law. If members of the judiciary themselves are alleged to be engaged in some wrongdoing, the processes laid down and spelled out by the Constitution ought to be respected. And that is exactly what has happened. I thank you very much. If there are any questions that you have, you may ask them.
So,
yes.
The embattled Chief Justice made reference to veiled threats on her life, and much as you're concerned about sticking to the sanctity of the constitutional procedure she needs to go through, you should equally be worried about this threat on her life. What's government's response to the specific issue about threats on her life?
The Chief Justice, more than anybody else, perhaps in this country, should be aware of the platform that is available to address such threats. Like if today somebody sends you a threat, you know exactly where to go to seek redress in the matter. And that is what I would say about it. Yes, Akusia.
One of the groups that petitioned, the Shining Stars group, the Chief Justice in her press conference indicated that her research done by her team show no traces of authenticity when it comes to that particular group, that the group has not been registered. Can you authenticate that group if we know anything about the Shining Stars?
First of all, I'm not sure whether there are provisions covering this, whether there's a requirement for authenticity, as it were. There were also individuals. How do you authenticate the individuals? What matters is that they have raised issues. And the Chief Justice was given opportunity by the President and the Council of State to provide initial responses, which then form the basis of the determination of a prima facie. The President, in consultation with the Council of State, came to the conclusion that there was a basis to proceed further. The President then, in accordance with Article 1466, I believe, set up the committee as spelled out by the Constitution and gave them the petitions to look into. The processes have been ongoing for quite some time now. So as far as the President is concerned, every law, rule, or regulation or process that has to be adhered to has been respected. So I do not know how this particular matter in any way impinges on the integrity of the process that has gone on so far. But then again, the Chief Justice has had cause, at least on 5 occasions. The Chief Justice and others, I must indicate, have had cause at least on 5 occasions to go to the Supreme Court to seek redress in the matter. And on all occasions, the Supreme Court has upheld the process as is currently underway. And so that, for me, should resolve the issue beyond any reasonable doubt. Yes, Max.
Yeah. Okay, so my question is there any timeline that we're looking at for the committee she made that point clearly and forcefully that she's not going to resign. I'm curious to know whether there's a specific timeline by which this hearing, should be done.
As I've been at pains to explain all evening, the president can only proceed on the basis of law. The law spells out what can and cannot be done. The Constitution does not set a timeline, and therefore the president cannot impose a timeline. Indeed, at this moment, the matter is entirely out of the hands of the president, insofar as it is seized with the committee. The president cannot direct the committee on anything that they should or should not do. So it is only they who can determine the processes that are laid down to undertake this particular activity. And as and when they finish and make recommendations as stipulated by the 1992 Constitution, the president is bound to act in the manner that they recommend. So I am not in a position to speak to any timeline. Neither is the president. It is only the committee that can determine when sufficient time has been had to look into the matter. Yes. Is there any? Yes.
Mm-hmm. Are there any specific reasons why the hearing has not been done in camera? Because we know the Constitution says it clearly in 146.
Well, you have your question is self-explanatory. You've answered it. The Constitution says it should be done in camera, which means it should be done in secret. Yeah. Yes. So it has been done in secret, not so. Yeah. So why can there be a complaint about what the Constitution? First of all, there are two things that we must distinguish from each other. You can disagree with the constitutional provision. There are many in this our country who have criticized the use of contempt by courts to punish people who they perceive run extrajudicial commentary on cases that are pending. There are many people who have disagreed with it. Indeed, I have on occasion expressed my disagreement. But that is the law. Until the law is changed, you cannot say that you disagree and so it should not be applied. Same applies to this particular process. So whatever view you may have of it cannot stop the law from working. And that must be clearly understood. So we must separate criticism or misgivings about the law as it stands from adhering to the law. And as yet, nobody has been able to say that this particular law under Article 146 has been violated by the president. And that is a point that must be stressed to the hearing of all. So if the law says that this process must be held in camera, the president has no choice than to act in ways that respect this. And I believe the committee is also respecting it at this. Indeed, the Constitution does not allow for commentary on the substance of the allegations. And there are those who may criticize the Chief Justice for violating same. We have not done that. And as I have indicated, I am not prepared to speak to the content of the petitions because we are not allowed to do so. And the president has acted in ways that the Constitution stipulates. So there cannot be a problem with this. That is why all those who have spoken have not been able to point to one evidence of infraction by the president in all of the things that have happened thus far.
Finally, we are getting this news that the Chief Justice and her legal team has filed a judicial review at the High Court.
She is entitled to do so, and we encourage her to avail herself of any opportunity there is to vindicate her rights. Yes.
Honorable, the suspended Chief Justice in her press briefing mentioned that she has received some call from individuals asking her to resign willingly or voluntarily to save her image. Has any government official or you yourself in any way called her to resign willingly to save her image?
Why would I do so? That will be the basis for me to play such a call. I have not. I have never spoken to the Chief Justice in my life. Second, no government official has placed such a call. If individuals in their private capacities, in their private lives, believe that they have a relationship with her and want to call on her to act one or the other, it is a personal decision that she would have to take. But government or the president cannot force her or even suggest remotely that she should resign. So that must be placed on record. To be fair to her, I don't think that she said that any government official has asked her to do so. So we must also correct the records as they stand. Yes.
Oh,
yes.
The first time, the Chief Justice leaked her own response before getting to the President. The second time, she chose to hold a presser and level serious allegations against the government. Do you suspect that the Chief Justice has an ulterior motive to paint this government black?
Well, I cannot ascribe any motive to the Chief Justice except to express regret over an act that may appear to violate the Constitution. But I don't think it would be fair to ascribe any motive. As I said, she has every right to adopt any measure she believes will aid her make her case, except that we all know that it is better to do so using lay down processes. Beyond that, I don't think that anybody can ascribe any ill motives to her. We have a responsibility to correct any misimpression created about how the president has acted. That is the responsibility that I am discharging today. That is all that there is today. Indeed, if there had been no references to murdered judges and the venue, which is a state facility, or some political vendetta or agenda, I will not be addressing you. If it had been purely based on sentiments about the outcome of some court cases, or even the process that the committee is using, we would have no locus to wade into the matter. If the committee is minded and they have a way to engage the public, so be it. But I have only addressed you for the sole purpose of correcting what is a false impression that there's some political agenda at play, or that the venue has been chosen for purposes of intimidation and as a way of using some dastardly occurrence in the past as a psychological tool to wear anybody down. That is what we decry. We don't think that it has any place in this discourse. It is most unfair, most unjustified, most unwarranted. And that is the reason why I have been compelled to speak to you to clarify that matter. Thank you all for coming.
The state in charge of government communications there, Felix Kwakye-Ofosu, just giving us a breakdown of government's position on the suspended Chief Justice news conference that she held not too long ago. Well, in response to the suspended Chief Justice's allegation of a political agenda behind efforts to remove her, Felix Kwakye-Ofosu dismissed the claims. He says they are unfounded and false when it comes to concerns about the choice of venue for the proceedings. He clarified that Edu Lounge, located near Osu Castle, is a public state-owned facility. And according to him, Coach, there is nothing intimidating about the location. He goes on to state that the decision to hold the hearing there was made at the request of the committee and not intended to create fear or exert pressure on the Chief Justice. Some of the key concerns that have come up earlier today, and we've just been getting thoughts from industry players, as well as bringing you that live coverage of the suspended Chief Justice news conference, the first time that she decided to speak to the media. Even after that supplementary affidavits gave us a sense of what is going through in her mind, she decided to talk to us officially for the first time. And that's the Felix responding on behalf of the presidency, just addressing some of the key concerns she has raised. Well, you're still watching the Joy News channel. We're handing over the baton to the business team as we bring you more on this in subsequent bulletins. You also have to stick and stay with us on all our social media platforms, as well as on Joy FM. We'll be expanding the conversation on Top Story and Newsnight as well. My name is Faustina Safo. It's been a pleasure doing the over 2 hours with you. Have a pleasant day.